All right, go ahead, Judge.
Okay. Good afternoon. Members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there's a conflict of interest or appearance of conflict. Does anyone need to disclose any conflicts? I'm not hearing any. So I want to welcome all of you to the subcommittee meeting. It's the Ethics Subcommittee studying the inquiry of staff regarding the use of notes function. And I'm going to immediately turn it over to our all helpful Assistant Ethics Counsel, Nicole McClellan, to give us a summary of the proposed opinion.
Okay, so I'm not going to summarize like where the content of the guidance. I think we all are well familiar that this is about making statements to or making the DA or the ADA adding additional language to the notes feature on the task function of the Odyssey system. So where we are in all of this is that you see the draft of the guidance. At our last subcommittee meeting, you all asked me to include specific language that the subcommittee or the ethics committee recognizes that private counsel doesn't have access like the DAs do, and that although it remains a concern, there's basically that we can't do anything about that. We don't have the ability to make changes to the Odyssey system. So we presented it to the full committee for discussion, and the discussion really centered around whether or not the guidance should include specific examples of what information or language would be either constitute ex parte or prejudicial to the administration of justice. In the guidance and what the original inquiry was that the DA included that the defendant had been called and failed twice or 4 times or whatever it was. And so we discussed whether or not, if we're going to include the specific language, Mr. Anglum prefers that we include language that has already been adjudicated by the grievance committee as prejudicial to the administration of justice. So there was language or discussions about that. I looked everywhere that I could think of to look. I used, on the State Bar website, you all know that you can look at prior public disciplinary orders. So I don't have access to anything that's like an admonition or a letter of warning. But I looked for, I did a search for the buzzwords. So I looked for parte. You can't put more than 1 word in the search engine. I looked for prejudice. I looked for justice. I looked for administration. And I got a lot of orders of discipline that included those words, but nothing that really fit with what we're discussing. So I found lots of discipline for lawyers who were obtaining ex parte emergency orders in a custody matter. It wasn't so much about the language that was in their motion, so much as it was they didn't tell opposing counsel that they were going. And what we're looking for is language that gives examples of adding additional information into a pleading or an order that gives that lawyer a leg up with the judge, where you're trying to make additional arguments. So I'm sorry, but I came up empty. And so I'll let Brian speak to what his efforts were, but we weren't able to find anything. I did send an email to Carmen Bannon. She's ethics counsel, and she hasn't had a chance to look at this. So I don't know if she can think of anything, but at this point, I don't have any additional language that we can say.
So yeah, I talked to Carmen earlier today, and I talked with her about this before and asked some of the other deputy counsel about this, and they basically indicated that they couldn't think of anything. Like, there are a couple of cases they thought, well, think there was this particular attorney, and I went back and looked, and it wasn't directly on point. So I'm trying to, trying to find other ways to, I guess, find other documents to search. But right now, it kind of feels like the needle in the haystack if we don't have any name of particular grievances. And of course, ethics is detached from grievance in that regard. So, but I guess I'll also add that, one of the things I think is up for this discussion, is the nature of the language used. I think the use of the language that we included, it was intentional in the draft. And this is, to be clear, this is a part of, like, this is the discussion to have. If you have kind of the, and the example being kind of some of the truly egregious, then of course everyone's going to agree that you can't say that stuff. But when you have the example being something that is, somewhat, I guess you'd say, just kind of almost transactional and nothing that's terribly inflammatory, it may illustrate the point that much more as far as what can and cannot be included in there. It's kind of like our 2019 FEO 4 opinion on ex parte communication, where it goes to the length of talking about administrative orders. Or excuse me, not administrative orders, but administrative discussions. Hey, judge, are you going to be around tomorrow at 2 p.m. because I've got a motion to continue that I really need to be heard? That sort of discussion should not occur in the courthouse hallway, even if it's just about, are you around tomorrow at 2 p.m. unless opposing counsel is there. It's the nature of ex parte communications. And so I think that's the thing where I will just say, from the perspective of drafting or having a part in drafting the guidance, we did kind of draft it intentionally to be something that's not terribly inflammatory. And that was to illustrate the point that regardless of whether or not this is really damning or just something that was unsolicited, extra information that simply isn't necessary to say, the advice, the caution remains the same. Don't put substantive stuff in the task or the notes feature for that task function. So that could be a part of the discussion here. But like Nicole said, my own efforts to try to find something that I could hang my hat on failed. We haven't been able to find any specific language.
Okay. Nicole, is this a good place for us to open up for discussion?
Absolutely.
All right. So I'm opening, hopefully everybody had a chance to read the proposed opinion.
Guidance.
And I'm sorry?
Guidance. I was helping you find the word.
Thank you. Proposed guidance, and be glad to hear at this time any comments, criticisms, additions, requests. Be glad to hear from you. Would like to hear from you.
Well, I guess since I'm probably the loudest voice in opposition to some of the language used, I'll chime in, and I'll chime in from this respect. In some respects, and with all due respect, I disagree that some of the things we're talking about are actually defined as ex parte because they're not directed as a judge. The fact that a judge can find them, and I know we're kind of beyond that. But it kind of says, because we can't find language that is not sufficiently inflammatory as to, in some sense of the word, be prejudicial to the administration of justice. I hate to go back to square one, but it brings me back to square one is, then why are we doing this? I mean, I know there were examples sent to staff from judges that they were concerned with. But I guess the question is, and I would have to defer to a judge, is in what way does that statement equate to an ex parte communication? The fact that and the reason I say that is because we, the prosecutors, aren't the only ones that can do this. Public defenders can do it, right? So, I mean, part of me is like, okay, if Tom's vote doesn't count or Tom's vote is nay and everyone else is yay, and this is what you're left with, then I would propose you change this guidance to include public defenders, or even broader, any attorney that will have the ability to note some content in some context, information that will go into the record, that if a judge wants to go looking at all those tasks individually, right, even though it may not have anything to do with the actual case that's sitting in front of them, fine. Okay. So that, if we're going to say this, then really and truly, then this guidance applies to public defenders as well. It would apply to any attorney who, let's say, in a perfect world, they change Odyssey to the point where in 2 years, counsel can now have access and do the same thing that I can do, right? Task something to the clerk instead of file and serve, because I know the notes that they can put in file and serve don't stay in the file. They stay within that file and serve document. But technically, even that's part of the public record. So really and truly, any attorney, when they file and serve something, can put something in there that, in some sense of the word, could be benign, inflammatory, but yet be construed in the future as an anticipatory contingency ex parte communication. And that's the way I basically look at it. It's almost like an anticipatory ex parte communication that when a DA puts this note in there, if the DA puts the note in there, that's the idea behind it. And so, I guess I'm looking at it from two perspectives. Number one, if we can't find the language that would be sufficiently inflammatory, and I'm not sure, I know the prosecutor over in Pitt County used some pretty inflammatory language on a dismissal form, right? And I don't see the difference between that and me sending a dismissal and a task, or sending, if on a motion to continue, sending a note that, of what you claim within this guidance as being ex parte or inflammatory or prejudicial to the administration of justice. So I think there is language out there that does qualify to be inflammatory or prejudicial to the administration of justice. Granted, it was language that was done and submitted after the case was disposed of, and it wasn't sent to a judge. It was sent to the clerk of court, but the judge certainly became aware of it, and rightfully so. And that prosecutor was punished because of it. I think back to all the stuff that went on in Durham post-Nifong and the removal of that DA. And granted, a lot of things she said in pleadings. I understand that, right? But that language is still prejudicial to the administration of justice. So I guess that's kind of where I'm coming from. When we have something that, in some sense of the word, we have differing opinions as to whether what's being said is benign to the advocacy argument or inflammatory to the advocacy and argument, I think we're just opening ourselves up to the uncertainty of the realities that we're going to deal with as a group, right? I mentioned this to Brian. I have a peer of mine, Jonathan Holbrook, did a presentation at the Public Defender's Office's conference this past summer or this past year sometime. And when he talked about just the things that could get prosecutors in trouble, he was in some sense of the word accosted verbally by public defenders who were chomping at the bit. Now we know we can report prosecutors to the bar for this behavior. So yeah, part of me is like, why? I guess I go back to school. Do we really need to do what we're doing? Number one, and if we are going to do what we're doing, then we need to make sure we're not picking language that is benign in some sense of the word. Advocacy exists within it, or inflamed. I mean, and if it is benign, then there's nothing wrong with it. But when the language has multiple aspects to it, and may in fact be factually relevant to the case. In other words, there's no misstatement of the fact. It's not like the prosecutor is not being impartial or having, if we're going to claim it to be ex parte or communication with the judge, the prosecutor then is not, is in that sense of the word, is showing impartiality, showing decorum, because that's exactly what a prosecutor would say if they stood up in court. So if that's what they say when they stand up in court, and that's acceptable in that setting, and the comment is never intended to go to the judge, then why are we punishing that prosecutor for potential language that was never intended to go before a judge? And again, I talked to Bill Powers a couple of weeks ago. We talked on the telephone, and I told him, I was like, the idea behind the guidance is good. I think it applies to every lawyer who at some point in time either currently does or will in the future have access to this content, right? And because of that, I think the rules that we have in place cover what this guidance seeks to expand upon. And I think when we expand it, what you're going to find, and I know we talked about this before, is what you're going to find are prosecutors remaining moot. Prosecutors saying, no, that's got to be a hearing in district court, right? And if that's the goal here, in order to, in some sense of the word, slow down the slowest processes that we already are slowing on, it'll work, because that's what will happen. It'll slow us down to the point where judges won't be aware of the content of the record prior to going into court for those hearings. So, and I know I'm rehashing a lot of things, but that's kind of where I am. Thank you. Thank you, Judge.
Thank you. We appreciate your comments. Appreciate anybody else's comments as well. Let me plug something in here. Maybe this will help, or maybe it muddies the waters. An addition might be, and I just thought of it, Nicole, or I would have sent it to you earlier, but while Tom was talking, it made me think of something. Yesterday, I was in our DWI courtroom, and they send me notes saying this is state's motion to continue, defendant's motion to continue. It's just an information about what is coming in front of me by way of task, which is not a problem. But I think I mentioned to you all before that in Wake County, we have a process that if a defendant has missed court and there's an order for their arrest out or called and failed, they can fill out a form, a motion to strike the called and failed. That motion then goes to the DA's office. And the DA gives an opportunity to say something, and that's where they would put, and I think appropriately so, because the defendant has now communicated to the judge, because ultimately this form is coming to the judge who called and failed them or issued an order for their arrest. Person who got called and failed gets to write in whatever their reason is for why they want the motion stricken. I was sick, I was in court somewhere else, whatever the reason. It then goes to the DA, and the DA has several choices. They can choose take no position, which is a block they can check, or they can say a line or two about what they want to say, called and failed 2 or 3 times before. And we're inviting that process by the form. I don't find that to be ex parte, because either you're going to, and I guess that was Tom's point, either you're going to not let anybody ever file a motion to strike the called and failed, or you're going to have to give the DA's office their opportunity to say something in response to what the defendant has said. And in that case, both people have then made their comments. So in my mind, it's not ex parte, because you've given both sides the opportunity to be heard. Now, Eddie's shaking his head, so I don't know if he disagrees. But otherwise, from my perspective as a judge, if you're going to allow a defendant to say anything, whatever they want to say about why they didn't make it to court, and you don't give the state an opportunity to say anything, then I don't think that's fair. So then what's the other's choice? Make everybody wait till we come to court. You know why that's a problem? Because people's licenses get revoked, orders for arrest have to get served. But if you're going to hear from one side, you need to hear from the other side. So that's my 2 cents.
And Judge, I was shaking my head because I was in agreement with you. I do not believe that to be ex parte. I don't
Okay.
know. I'm new to the committee. I'm just trying to find my way. But I don't believe with both sides being heard and with each side understanding that the other side is going to be heard, I do not believe that's ex parte. Much like, pre Odyssey, if, in Mecklenburg County, if I went to the DA and said, hey, do you mind if I approach the judge and have the judge sign this form? And the DA said, yep, I don't oppose. I approach the judge, say, Your Honor, I've talked to ADA Williams. They do not wish to be heard on this matter. They're in agreement here. Would you please sign this form? That's not in my experience, that's not ex parte either. So I think it's about just both sides being here. I think the issue here is, again, I think there's two issues. One, it's the additional language, and it's also ex parte. And so the additional language that we're talking about, and I think it's part of Tom's issue with the guidance, is the additional language an issue. We keep coming back to the same thing, no matter how far along we go. We keep coming back to that language, and if that language is the issue, and I keep having the same opinion, and that is, why just not save that for the judge? If it's not that big of a deal, why not save that for the judge? The idea that this is on for in order for a rest strike, that's something that's needed to manage the docket, to let the judge know what's going on that day. The fact that the defendant has had 2 prior OFAs, that's not needed. Now, if in your county, you've told there's an understanding between you and the defense that I'm going to pass this up, and I will let the judge know about this additional OFAs, and the judge can do whatever. I think you can put that in the task to sort of say, defense counsel, we've agreed that this language can be added or whatever. But ex parte, but the additional language, especially without the opposing counsel being notified of that, that's a problem. And for the record, I read the guidance. I'm in favor of it. I think it was worded great. I think it put real life examples in there that we deal with every day. And I don't think this is meant to necessarily be a gotcha for any attorneys, or especially DAs. I think this is just meant to provide some guidance for a new system that we're all dealing with. And I thought it was a great guidance.
Other comments, questions?
Briefly, if I could, Judge.
Go right ahead, please. We would like your input.
I would just say that I still disagree that that the language that we're talking about addresses the merits of a defendant's case. I think it's an administration of justice issue where it's a case status issue. It doesn't have anything to do with the underlying case. If the DA had put in a sex offense case that the defendant had been suspended from school for improperly touching a female classmate, I think that would be an ex parte statement that goes to the merits of the defendant's case. But this is strictly a procedural status of the case. The guy's been, it's information that's going to come out anyway. It's not going to prejudice the DA by putting a note in there to remind himself of that. I don't think it's going to prejudice the procedure. And I just think I don't think it's necessary. And I do agree with Mr. Anglin that I think there's some risk associated with taking this position that's going to impact, it'll impact the state more, but I think it could impact both sides. And I think it's just something that quite frankly, we don't need. And that's my position.
Woodrina?
Thank you for recognizing me. Good afternoon, everyone. I'm in agreement with Eddie. And I think for me, and it's something I've been talking about all week, unfortunately, it's about image, right? And so, yes, the state has access to this section. public defenders have access to this section. As a person who's now chief public defender, but I've also spent many years as a private practice attorney, they don't have access to this section. So it's about image and what are we putting out there to the public. Think about it as a defendant who's coming into court, and they all of a sudden they hear that the state has put this message out there, where the judge got to see it, and they're looking at their attorney going, well, did you know this? Did you know this? And the attorney's saying no. So that defendant is already feeling like, oh, something is happening in the background that is my attorney doesn't know about, and they're trying to sneak something through. Not that we're saying that the DA's office or even a PD's office is going to put something in there that they really shouldn't. That's demeaning. It is the image of looking fair to the people that we're serving in that courtroom. And so I like the guidance, and I believe there is a section in there, I think it was on the last page, that basically told the public defenders that we're not to put anything in this message either, in this section either, that it just needs to be, fair and not put anything in there. I do understand it's going to slow up courts. I'm not a fan of slowing down courts, but if this is what we're stuck with, which we are stuck with enterprise justice and Odyssey, it's here to stay. We're just going to have to adjust to it. And using it, saying that it's going to slow down courts and that's why we shouldn't worry about it. There's a whole list of other reasons why enterprise justice is slowing down our court system. Doesn't mean that we sweep it under the rug and go, well, it's slowing us down, so we're going to ignore these factors and just keep moving forward. I like it. I agree that I believe it is ex parte when the defense bar does not have access to it, even though it may be procedural. He's had 4 call and fails before. It's still a communication where a judge is hearing from one side and not hearing from the other. And again, I go back to where I started off with. It's about image and the look of fairness to the defendant that's in the courtroom, and in some ways, even perhaps on occasion, a state's witness. Thank you.
Tom?
I guess I would hate for the bar to send me a letter for me putting this information in a note in response to a motion to continue that has been filed by the defendant. And if a defendant files the motion to continue, there's an expectation that the judge will see that. And if I don't have the opportunity, let's say I'm in court 5 o'clock the day before this motion is going to be heard, the morning of, the next morning, and I don't have any way to respond, then is that fair? I mean, and I guess because if I reverse the roles, if the public defender is saying, if I make the motion to continue, if I file that motion to continue, and the public defender doesn't have the time to file a written response, and the only thing the public defender has the opportunity to do in notifying the court of its position is to write, hey, I oppose the motion to continue. It's been continued 6 times for the state. They've never had their witnesses there. The defendant is ready to proceed. Well, you just implicated the inability of the state in that statement to get its witness in court. That's advocacy. You are trying to influence the decision of that judge based upon the note that the public defender puts in there, right? in my experience, do I care that in ex parte communication, then for the same reasons, you're going to have public defenders calling the bar on prosecutors. You're going to have prosecutors calling the bar on public defenders. And the question is it really to the prejudice of the justice system that that language be used in that context, when we realize, as Judge Foster said, that when we get before the judge, that's where the arguments will be had. It may be factual in nature, and what the public defender says may be factually accurate, right? But it's advocacy. And whether the public defender intended that to be read by a judge doesn't matter according to this guidance. And if we're going to treat that the same, then let's change the facts to include a factual scenario where the public defender put something like that in there. That way, this guidance will be fair on both sides from that perspective, right? Because what you're doing is you're basically handcuffing the state to respond to those types of situations. And I don't think this guidance should do that. Frankly, I don't think the bar should do that. And I think that's what we're doing. I think we're, in some sense of the word, I think this guidance steps outside the role that we have. And maybe we should just wait and let's get Odyssey into the system and see how many complaints or see how many of these things really happen, as opposed to, oh, I'm concerned about, because we know the original complaint was factually impossible to implement, right? So, again, that's my concern here. From where I sit in my experience of doing this job for 30 years, having been involved in the electronic discovery stuff, I wasn't involved in Odyssey. I'm thankful to say they didn't include me in that fiasco, because it is from that perspective. And I disagree wholeheartedly that the council shouldn't be able to see what's there, because I think that's the nature of what we do. But I think if we're going to do something like this, then it needs to be equal across the board. It doesn't need to pick out one side or the other. It needs to be applicable, frankly, to all attorneys that have access to Odyssey. And so it shouldn't distinguish what language is acceptable or unacceptable from one side of the bar from the other side of the bar, right? And because in my experience, I could talk about stories I've had public defenders do stuff like that, and I just let it go, because the truth of the matter is we are, in some sense of the word, an adversarial system, and that's expected in some respects. And that's why I kind of hearken to Judge Foster's statement. Those that are in the system, the way we're in the system, know when to make that call, right? Where that line is. And sometimes it's obvious, sometimes it's not, but it still that call needs to be made. And I'm just afraid. I'm just telling you, that I think what we're going to be doing is opening the door and going down a slippery slope, when we really and truly not even sure if it is an issue as we sit here today. Thank you.
Eddie?
Yes, I want to address this, because this is the second time that the point has been made in terms of, public defenders or private attorneys need to be included in this to get the, with the same language, the same example. From my understanding, the way that this works, we went with this example because that's what was given to us, and we were trying to answer the question that was proposed to the committee. And so taking what the question in terms of what was acceptable by the DAs to do in Odyssey, and if this is okay. And so we're trying to answer that question. But I think everyone recognizes that this will be broader than just applying to only ADAs. If a public defender is including additional language in a task, then that's an issue as well. And the guidance will support that. Just because it may use an example of an ADA providing additional language. If a public defender sends in a motion to continue and say, this is the third time on, the state has had two previous continuances, so I'm just asking for my one freebie. That's an issue as well, and I think the guidance that we will issue will point to that.
I like Tom's suggestion that you use one from the other side so that we've got saying the public defender's office as well. I think that's fair. Tom, you at a point?
Yeah, I guess, and in response to that inquiry, Eddie, having been at the council for 5 years, there have been ethical questions asked of the council, and we've expanded it, right? Because of the realities of when we deal with these ethical questions, that we recognize that it's not just about answering the question that's asked. It's make sure we answer it in a manner consistent with the obligation of the state bar to protect the public from with respect to those individuals who are practicing law. So, I mean, I understand your point about answering the question, but I think it's often, Brian can speak to this. I'm sure Judge and Nicole can. Sometimes we kind of expand the ideas to include other behavior from that perspective, but I understand that point.
I'm trying to look and see if anybody else had their hand up. Even if you don't have your hand up, feel free to talk. Go ahead, Brian.
I was gonna say I feel like there's a lot of things that have been said that I think we all probably agree with. For one, this type of communication is only bringing up the ex parte aspect to the extent that private defense counsel is on the other side. And I think that's something, because we all recognize private defense counsel doesn't have any access to it. And so anything that gets put in these notes features, if it gets tasked to a judge and defense counsel does not have any reasonable access to it, I won't even say just plain any access, then that's a communication to the presiding official that the other party is not aware of. So I guess I think that's something that seems like we all agree on, and that's where the guidance is only focusing on ex parte with respect to that scenario. Otherwise, it's not ex parte when you've got public defender on the other side and ADA puts this in, or vice versa. And I got to say, I agree with that too. I think maybe that would make the guidance that much clearer, because Tom, you're right. This applies to all lawyers. Anything that is thrown out there, substantive, that's not a part of setting the docket. Like, and I think Eddie, you were kind of thinking of or recited a scenario that I was thinking of. Maybe we create a different inquiry that says public defender has tasked a motion to continue to the presiding judge, and put in the note section, state has received 2 prior continuances due to officer's failure to appear. And it's one of those things where, like, that's what you would say in support of why you're requesting this motion to continue. I don't think public defender should put that in the task or in the notes function or note section. They should just have the motion to continue. They can offer their reason why they think the motion to continue should be granted in court and not through this administrative electronic system. And so I think you're right, Tom. Having an example from both sides would make it more balanced, because this does not need to target ADAs. The scenario that was presented to us at first was ADAs, and I think that was, kind of the context of this. My understanding is that ADAs at first were the ones that had access to that to enter notes, and then public defenders were granted it. Anybody with the eCourts.gov address. So it kind of evolved as it went on. But you're right. This applies to everyone, and if private counsel ever gets access to it, they too should not be putting crap in there. And I think we can make the opinion that much clearer. And I guess the last thing I was thinking, Judge Bell's point about what we do in Wake County and the things that Eddie was describing in Mecklenburg County. I think 2019 FEO4 would support the notion that if the court has invited that communication, be it by local rule, by custom, anything like that, then that's not going to implicate the rules of professional conduct. The process in Wake County, I agree with you, Judge. I don't think that's problematic for the rules, especially because that is something that the judge expects to happen. It's always supposed to be this, or I guess the opinion, and where we run afoul of the rules is when lawyer basically provides unsolicited substantive information to the presiding official. And that's supposed to be, even, if opposing counsel is not copied, then it's ex parte. If opposing counsel is copied, then it may not be ex parte, but it's still prejudicial in the administration of justice because it was unsolicited substantive information. So I think there's a lot that I feel like we're actually probably on the same page for. And maybe we start by including a new inquiry with a public defender as an example. And to maybe note that, that there may be other processes in different districts by which the judges have established, the courts have established, I guess, the ability of the litigants to contact the presiding official. And this guidance doesn't seek to undermine that and undermine the court's ability to deal with its attorneys. That's statutorily in Chapter 84 to say the state bar is not supposed to interfere with the court's ability to handle its attorneys to do its business. So maybe we can make that much more explicit.
Thank you, Brian. I have a couple. Number one, my ultimate position is we do nothing. Okay, and I'm saying, and I understand because, and this kind of leads to my question. Do we actually have, you mentioned previously that you've had some judges express some concerns about this, but have you actually had circumstances, specific language that kind of goes into what we're talking about? And this is where I want to be clear. Yeah, I think any attorney that works within Odyssey that is about to send a task to a judge should be thinking twice about sending a task to a judge, unless the judge has invited it, as you've expressed. And I can count, to my recollection, since we've gone live in Odyssey, I have never tasked anything to a judge. The clerks have always tasked to the judge. That being said, I'm curious if we really do have, other than the inquiry, which was, I think, factually inaccurate within the confines of the capacities of Odyssey, do we actually have inquiries by judges to say, hey, is this ex parte, and what do I do about it? I'm curious.
Yeah, and that's where I think she had to jump off, unfortunately, but Brittany Pinkham, the director for judicial standards, she reached out to me last fall.
Right.
To say, like judges had called her saying, am I supposed to look at this? Should I be talking to my attorneys about something? I'm looking at, and I don't think it is inappropriate for me to share what I'm looking at right now. So I'm going to, let me make sure I choose the right screen. This was an example that was provided to me as a screenshot where something was queued in a judge's queue. And this was one of the note speaks, and it just says defense motion to continue to hire an attorney. Defendant waived in, I think it's supposed to be July 2022. Defendant called and failed 2 times. And it was that sort of thing that was kind of well, that raised the question to a judge of why are they putting that they waived in July and that they were called and failed 2 times? It has nothing to do with the current motion to continue, except to advocate for why the motion to continue should be denied. It is background information, and the judge could click on the other tabs to see it and draw his or her own conclusion, but kind of pointing the judge in that direction, I guess, as seemingly kind of just like reciting facts as this may be. These are the facts that would be relied upon to say, this, at least I interpreted that, and that was the interpretation that was also kind of mentioned to me from the judge's perspective of this seems like there's somebody trying to kind of get out ahead of it to say, judge, don't grant this motion to continue because here's the background on this. I just want you to be clear. And so that's like one of the examples that was provided to me, and why we came up with this scenario. Defendant called and failed 2 times. It was because of this very screenshot.
But
was that a prosecutor that tasked it to the judge?
That was my understanding. That was what was relayed to me.
So,
and is that,
and maybe Corinne has some other opinion, which I would love to hear, Corinne.
I was going to ask that same thing. Like it blacks out who did it. If this could very well have been a clerk. Now I do train clerks and judicial support staff to not do this.
Right.
but I could see it happening because, as Tom said, I don't think that prosecutors or public defenders, for that matter, I just don't hear as much from public defenders, are tasking things directly to judges. My understanding is they're tasking them to clerks, who then task them to judges. And in addition, I provided this information in one of our prior meetings, but there's differences in where the notes show up in enterprise justice, which is the case management system. If the note is being made within the enterprise justice system, which is only done for calendaring, is my understanding, when you're doing the calendaring within the actual enterprise justice system, that's when the note is going to show up in the notes section of the case. My understanding is that if the note is done through a task and attorney manager to the clerk, the note doesn't then show up on the case. That would be similar to file and serve for private attorneys. You could put a note in file and serve. That note's not going into the integrated case management system for the judges or anyone to see. The clerk is really the only one, the clerk reviewing that before accepting it into the system is the only one that would see that file and serve note. So one of the comments I had about the current write-up is it talks about tasking it to a judge, and it's not quite accurate. It's really if the DA or the public defender is doing the action through the integrated case management system as opposed to attorney manager and make a note, then the note, my understanding, will go on the case file, and it might be seen by the judge. It's not necessarily going to be seen by the judge unless the judge clicks on the notes tab. Now, if the PD or the attorney or the DA are tasking things directly to a judge from their attorney manager, I don't see that as any different than them sending an email. And I feel like it should follow the same rules as the guidance on ex parte email communications. It just happens to be in a task.
Correct.
But-
Can I ask you a question?
Yeah.
What you just said about the notes tab in the case manager, right? The note that is on a task wouldn't go to the notes tab in case manager. You actually have to go to the task and then go to individual task to click on those tasks individually in order to see what was in that note. So in other words, it's not on the
Yes.
summary page. It's not on the summary page of the case. So if this communication were done as a note to a task, the judge would have to go task and then look at the multiple tasks that probably exist, click on that task, which would then populate the screen with the content of that task.
You're correct, Tom, and thank you for making that clarification. I was just trying to, for people who don't use the integrated case management system, explain that it's saved somewhere in the case for the judge to see, but the judge would have to kind of go look and find it. And I forgot it was in the tasks. It's in the tasks tab under the notes for each task, not the notes tab, which is a separate tab.
Now, let me say this. Yesterday, I was presiding in DWI court. And the way I like to deal with the cases in DWI court, normally a DA would come and put the shuck up there and say, this is a motion or this is a plea, and they're saying it in open court. The DA will and the defense attorney may have talked, and the DA said, Judge, do you want me to task you what we're getting ready to do? And I say, yes. And so I get a task, and in the task it says, defense motion to continue, and here's a proposed new date. And then the defense, so I call it up. I say state versus whatever. And I say, I understand there's a defense motion. I'll hear you. And then I hear from the other side. And then if I grant it, I've got the proposed date. So yet in my courtroom, when I'm presiding in traffic court and DWI court, I do get tasks from the DA.
Because you asked for it.
Yes.
Yeah.
But that is standard practice in Wake County. That's not just Judge Bell in Wake County. That is the DAs, if it's going to anywhere but the clerk, it will go directly to the judge. That's a standard practice.
Can you elaborate on that a little bit? Is that like when you're in court or
You're in court, sitting on the
when you're
bench.
in court?
And
Yeah.
the
Right.
DA is there and the defense attorney, they've talked, and now it's coming up for you to either hear a motion, somebody's motion to continue states or defendants, or to talk about a new date, or it'll say guilty plea, continue sentencing, because they've said we're doing the pleading guilty and we want to continue sentencing. So they're just telling you what to call when you call the matter. But it does have that information in there. But I want that information.
But what you just described was the procedural information that the current guidance says, the current draft of the guidance is saying is fine, that defendant's motion to continue. That's just procedural, not any elaboration on the merits of that motion or something that would go towards a judge deciding that motion, correct?
Yeah, it's saying state's motion to continue, defense motion to continue, and it has a potential date if I grant it. Because the state's got to give you the date because they calendar.
Brian, I was curious, that task that you was sent,
Yeah.
did it, and having learned a lot more about Odyssey, did it have additional tasks? Did it have documents to view? Did it have responses from, because when you open up a task and you start it, you'll get these headers that will say, there are 3 documents attached. You can click view. So because I guess my question is, if that task was actually started by the clerk and then the judge forwarded it or moved it to another person, or a person forwarded a task that was sent to them from the clerk, so I guess I'm just trying to make sure that we got the complete history there, because like Judge Bell, I want you to come down whole court in my county. Yeah. Because this idea is getting the complete picture of what's really interacting between the court and counsel and again, I'm not saying that the guidance is bad. I'm just saying that, are we really at that point where we can say this is what it should look like from the bar's perspective? Because if we say this is what it looked like from the bar's perspective and their local rules don't accommodate what we're talking about, then are we causing more trouble for prosecutors and public defenders and lawyers when it comes to this issue? Yeah, right. I guess that's.
Yeah, no, I think that's a fair question. I only received, essentially a screenshot, and it is limited. I don't have access the way that other folks have access to the system, so I can't click around or to see, exactly what. Like I want to do a deep dive into this case file and see exactly what's there, but I just don't have access to that. And so maybe we need to look at that. And I guess that's, to me, the question of, I guess maybe say, as far as the question, the background from our experience was, in terms of ethics counsel receiving calls, we did receive calls. Nicole can talk about that too, that, folks in the private defense bar were calling, and questioning them, they don't get access to this. And like I said, my understanding, Eddie, you can correct me. Well, I guess maybe Eddie, you all had access when Mecklenburg got it. My understanding was, kind of initially Wake County public defenders did not have the same sort of access to enter task notes, but then they eventually got it. And that was something where I have to say, when we were getting calls, initially our response was, this is a new system. And that was something you saw the state bar president, Marcy Armstrong, put out a full kind of press release to say, folks, don't fear the bar coming after you as we try to figure out this new system. It's a brand new system. There will be kinks to work out. It's like, I'm reminded now that Apple just released iOS 18. There's going to be all sorts of bugs, and people will complain about it, and they will have to update it. It's just the nature of what we deal with when it comes to technology. And so but the questions that kept on coming into us was, about these things, that there seems to be an avenue of communication. And so that's where it kind of became, especially once we got the call about judges also inquiring, what am I allowed to look at? We thought, well, maybe this is the time to just kind of set the base level of lawyers, you know that this opportunity exists, and we want to encourage everybody, don't take the opportunity to add substantive information that you otherwise would be using or articulating when you advocate for your particular position. That was the intent. If we have gone off base and that would not be the effect of this, then maybe we do need to rethink how we're coming across. But that I think is, I interpret what we have drafted as communicating that, and I think it would be clearer if we had something for the other side, so it doesn't look like the bar is coming out saying the DAs are misusing eCourts, because that is not what the intent was here. I think it's just that this system provides an opportunity for folks to potentially misuse it, and they need to be aware, save the advocacy for the courtroom. That's the thought.
Brian, I think what you just said, if we could distill that without going into details for both sides, for anybody, I think that would be my recommendation, number one. Number two, I also, because this is an educational thing, at least for the part of the prosecutors, I was at the summer conference on behalf of the bar. I did a presentation, and I talked about this issue. I'm going to go do it again in October at Kitty Hawk, and I'm going to talk about this issue. So, you know, I'm hoping that maybe as time goes by, and I'm not sure if we can wait or should wait. I understand that, but maybe the more information we get out as prosecutors, the more prosecutors will realize that, hey, if you're going to put a note in a task, you know, be cognizant of your ethical rules when it comes to the idea that could be perceived as an ex parte communication, and go from there. So again, I mean, I guess that begs the question: do we need to do it, or do we need to wait on it? But I mean, that may be another question for a vote to go forward. I don't know.
I would like to suggest that we do a couple things. One is add the example about the if we're going to do it, add the example about the public defender. And I would also like to see us say the language we were talking about too as well. If the local rules or practices allow both sides to present information in writing, this guidance does not apply. If you put all three of those things, then I think the concerns we have about people feeling like we're targeting just DAs, and about other practices that people might go, wait a minute, can I still do this or can I still do that, might address all of those things.
Yeah, if I could just add one other thing, then I'll hush. You know, the bottom line, I think that I'm concerned about too, is I still am bothered by the lack of access that the private bar has to this thing, and I think I would like to see us do some kind of correspondence to the AOC and to the Chief Justice. I mean, this is a real access to justice issue, and he's big on that. And I think there's some fundamental fairness issues where an entire group of players in the system don't have access to what the others have access to. And my suggestion has been, you know, let AOC designate the type and style and model of a computer, and let the lawyers pay for the computer and have the software they need put on it, and then they have access as long as they keep it updated and follow the procedures and rules, because that's their concern. But I know that that's beyond the scope of what we're doing here, but that really is a fundamental problem that we've identified, and I really would like to see it addressed at some point in time somehow.
Maybe we can do that I also serve on the Access to Justice Committee of the State Bar. Maybe that's something to relay. If the subcommittee wants us to relay that information to our president, we can see what the president wants to do about it, if anything. Don't know.
Yeah, I'm not sure that the ethics committee should be sending that letter. So, Brian.
No, I'm just saying,
Okay, I
relay
would
the
think-
issue,
Yeah,
the issue of access, not a letter, but
I'm not saying
relay.
it should be this group, no. But
What I'm suggesting is that maybe we should mention to the bar, and I'm glad to do it, mention to the state bar president that our committee came up with this issue came up while we were discussing notes, and we wonder if that should go to the Access to Justice Committee. I think that's the committee to deal with it, that deals with those kinds of issues. But I'm saying I don't want to speak for the committee. Y'all may want me to be quiet. And you can say that in this context.
I say give her a soapbox to stand on.
I will say this about they don't have access to it. A lot of things are being done by tasks now that have historically been done by emails, and that was not something that was readily. I mean, you can make public records requests for them, but it's not something that was out there. You know, an attorney couldn't walk in and look at the case file and see the emails between the judges and the parties and stuff. So historically, that's not something that's been readily available. It is available, but not readily available.
Well, I think historically, the private attorney will probably be included on the email between a DA and and the judge. Yeah.
Mm-hmm. Yeah.
The comments we're at 2:03, and I know we were supposed to be over at 2, but I didn't want to cut off the discussion, but I don't want the people to have to leave because they got to go to places, and I understand court and otherwise.
Well,
so
Judge, if I can
Yes.
summarize, I think I understand that we're going to add that, like you just said, we're going to add that inquiry. Let's kind of review this language and maybe circulate again to this group and see what the impression is. Because if the impression remains kind of a big, what exactly are we addressing, or does this actually make it more helpful? With that being the goal, this is not a formal ethics opinion to be added to the canon of North Carolina State Bar ethics opinions. This is supposed to be guidance that gets approved by the ethics committee, but then it basically is provided to AOC, Conference of DAs, Conference of Public Defenders for dissemination to folks in training purposes. But this is something that the state bar has weighed on with, input from a variety of groups, and here's our kind of cautionary wisdom, such as it is. But I think maybe let's see the next draft and then react at that point.
I think that's right.
All right.
Anybody disagree with that? Do you want to take a vote on it? I don't want to be. All in favor of allowing the State Bar Council to take another stab at the draft and then circulate it? Can you say aye or yes or raise your hand or something? Any opposed? Okay, I think that's unanimous.
I think Nicole's opposed. Nicole's like, let's just be done with this.
Okay. Sorry, Nicole, I didn't see you. Are you opposed?
No, I'm kidding.
Okay.
I did not want to say that out loud.
I know, but this is what we do. We take a stab at something and we come back and we take a stab at it and we come back, and then it ultimately gets to, and we get to council. I'm like, yes, we have done some work on this. Let's approve it.
And it will be better because of these conversations. So I do appreciate that.
Exactly.
But we'll be in touch with everyone.
Okay. All right. That's all
Thank you, guys.
on my agenda. Anybody else had anything? That's all I understood we needed to discuss.
Yeah, I think we're good.
All right. Thank you, everybody. Sorry to run a little over.
Thanks, y'all. Take care.